Sir, can you turn it down, please? Are you where I stopped you?
No.
I saw you dealing a white substance back there, and it looked like the guy ran off after. So can you step out of the car, please?
Nope.
Sir, put your hands up. Get out of the vehicle, please. Show me your hands. Sir, you are under arrest for trafficking an illegal substance and evading a police officer. Hello, Mr. Walman. We are here to discuss the crimes you committed and what your next steps are.
Okay.
There's enough evidence that I can confidently say you'll be convicted of your crime and you will likely suffer a lengthy punishment. I am willing to offer you a plea deal, which will definitely reduce your sentence.
I know how this works. You're just trying to convince me that I'm going to lose in court so that I should plead guilty right now.
Mr. Walman, the Crown has sufficient evidence to convict you on both of your charges of trafficking a Schedule I drug and evading a police officer. It is most definitely in your favor to accept the deal I'm about to offer you. Here's the deal. The Crown is willing to drop your evasion charge if you agree to plead guilty to trafficking cocaine, which will put you away for 2 years instead of 2.5 years and a hefty fine.
I don't know. I would need to think about it and confer with my lawyer. Could I possibly get back to you in a couple days?
Mr. Walman, it's up to you. But if you don't accept this right now, I can't guarantee that I'll be able to offer this deal again. Think about your family. If this goes to trial, you will serve 2.5 years in prison and will regret every day you didn't lower your sentence when you had the chance. Legal fees are also extremely expensive.
Okay.
I'm telling you, you've made the right choice.
Mr. Walman was stopped by a police officer because he was seen giving another person a small bag that contained a white powder-like substance. When Mr. Walman was confronted by the police officer, he didn't want to answer questions and then drove away without the officer's permission, obviously trying to get away. Mr. Walman was then arrested for trafficking an illegal substance, being cocaine, and for evading a police officer.
The next clip shows a meeting between Mr. Zolf, the Crown Prosecutor, and Mr. Walman and his lawyer. In this meeting, the Crown Prosecutor intimidates Mr. Walman by telling him that there's lots of evidence against him and that if he does not accept this plea deal, he will end up losing in court. Mr. Walman, not wanting to risk more jail time and a hefty fine, ends up signing the deal and is sentenced to prison for 2 years.
Plea bargain, also referred to as a plea deal, is an agreement between the Crown Prosecutor and the defendant in a criminal case whereby the defendant agrees to plead guilty to a particular charge or charges in exchange for an agreement with the prosecutor to drop one or more charges, reduce the charge to a lesser offense, or recommend the judge a specific sentence which was agreed upon with the defense. Nowadays, it seems as if plea bargains are just being used as a way to save money and not go to trial.
Some pros of plea bargains include freeing up court space, reducing court costs, and jails would significantly be more filled than they are today. Cons of plea bargaining include criminals getting lighter sentences than deserved, prosecutors using the plea bargain as a tool to save money and not go to trial, and the criminal justice process does not fully occur because the defendant waives their right to remain innocent until proven guilty. The accused also waives the right to appeal by signing a plea deal in most cases, a clear disadvantage for the defendant.
Plea bargains are truly a necessary evil. As mentioned earlier, without plea bargains, our courts would be overrun with cases and the cost would immediately shoot through the roof. Our jails would also be filled to the brim with inmates.
And yet, it is sometimes not right. Criminals are getting a lighter sentence than deserved, and the victim's feelings are treated in a less than stellar matter. A prime example of a Canadian case that was settled by a plea deal involved a person named Anthony Hainmare. The case goes as follows. On September 29, 1987, a break-in occurred in the bedroom of a 15-year-old girl in Toronto, Ontario. The criminal was wielding a knife and was about to assault the young girl when her mother intervened and scared the criminal off.
The mother caught a glimpse of the perpetrator for seconds in the dark room as he ran outside and drove off in a white car. The victim's mother described her daughter's assailant as having blonde hair, blue eyes, small ears, and a baby face. This would eventually lead to the wrongful conviction of Anthony Hainmare, a man who was of absolute innocence.
Hainmare pleaded guilty to receive a sentence of 2 years, less a day in provincial jail, to avoid the threatened sentence of 6 years in a federal penitentiary, which was recommended by the Crown if he were to be convicted.
The Crown's case was very weak and was almost absolutely based off of flawed eyewitness identification and testimony. 2 months after the break-in, the police showed the homeowner a photo lineup, and she picked out Mr. Hainmare's photograph. He was arrested on December 18, 1987.
In 2006, Paul Bernardo confessed to the 1987 assault of a 15-year-old girl and provided a detailed account to investigating officers, who also interviewed Hainmayer several weeks later but did not inform him of Bernardo's confession. Hainmayer became aware of Bernardo's confession in late 2007, after which he appealed to the Ontario Court of Appeal in June 2008. As a result, the court cleared Hainmayer of the convictions, and Justice Rosenberg stated that it was profoundly regrettable that the errors in the justice system led to this miscarriage of justice and the devastating effect it had on Mr. Hainmayer and his family.
In June 2010, Hainmayer commenced a $1.1 million lawsuit for damages suffered as a result of his 1989 conviction for the assault. The courts made a decision not to compensate him, however.
One of the big problems we've examined throughout our research of plea bargaining is the use of intimidation and strong negotiation skills that the Crown possesses, which can sometimes scare the accused into quickly making a deal. One strategy we think can mitigate this unfair advantage is a new law being put in place. It would go as follows. Any meeting where some sort of plea deal is discussed between the Crown and the defendant must be on videotape and also transcribed by a court reporter.
By doing this, it gets rid of any possible discrepancies that could happen during a plea deal. If the defendant ever felt that their rights were violated, that they were intimidated or treated unfairly in any way, there would be evidence of that and a judge could review it. Plea bargaining is most certainly a necessary part of the Canadian criminal justice system. However, this could improve it and at the same time not completely change the procedure that goes along with it.